Angara versus Electoral Commission, GR 45081. Facts. The case was an original action filed by Jose Angara for the issuance of writ of prohibition to restrain and prohibit the Electoral Commission (EC) from taking further cognizance of the protest filed by Pedro Insua against the election of the former. Jose Angara and Pedro Insua et al. Were candidates for the position of National Assembly member for 1st District of Tayabas Province. On October 7, 1935, Provincial Board of Canvassers proclaimed Angara as the winner. Angara then took his oath of office. National Assembly passed Resolution Number 8 confirming the election of members of the National Assembly against whom no protest had been filed. Subsequently, Respondent Insua filed before the Electoral Commission a motion of protest against the election of Angara. Electoral Commission adopted a resolution, paragraph 6 of which provides, "The Commission will not consider any protest that is not submitted on or before this day, December 9." Angara filed before the Electoral Commission a motion to dismiss the protest on the ground that it must uphold Resolution Number 8 of National Assembly. Insua countered that there is no constitutional prohibition barring the filing of protest. The Electoral Commission promulgated a resolution denying the motion to dismiss the protest filed by Angara. Issues: whether or not the Supreme Court has jurisdiction over the Electoral Commission, as well as the subject matter of the controversy. Resolution of National Assembly, resolution of EC. Yes. Whether or not the Electoral Commission acted without or in excess of its jurisdiction when it assumed cognizance of the protest, despite the previous confirmation by the National Assembly. 2. It adopted its resolution in December 9. No. Whether or not Resolution Number 8 can nullify filing of protest or toll the time of filing protest, effectively rendering the resolution of the Electoral Commission moot. Answer is no. Ratio. Number 1. On judicial review. In cases of conflict, the Judicial Department is the only constitutional organ which can be called upon to determine the proper allocation of powers between several departments and among the integral or constituent units thereof. Section 4 of Article 6 provides EC, Electoral Commission, the sole power of deciding such matters. Also, from the transcript of the framers' discussion, it is clearly the intention of the framers to give EC sole jurisdiction over election protests. Each department of the government has exclusive cognizance of powers within its jurisdiction and is supreme within its own spheres, but it does not follow that the Constitution intended them to be absolutely unrestrained and independent of each other. Constitution institutes the system of checks and balances. Moderating power of the court is granted by clear implication from Section 2, Article 8 of the Constitution. The judiciary does not intend to assert superiority over other departments or deliberately nullify or invalidate acts of the legislature. It merely asserts the obligation assigned to it by the Constitution to determine conflicting claims for authority under the Constitution and establish rights for the parties. Power of judicial review is limited only to actual cases and controversies, and limited further to the constitutional question raised or the very lis mota presented. Number 2. On the legality of the Electoral Commission's acts. National Assembly has no jurisdiction over election protests, so it follows that they don't have the authority to prescribe the time or prevent the filing of protests. Separation within same branch of government. Electoral Commission acted within the legitimate exercise of its constitutional prerogative. It acted within its jurisdiction. The EC's resolution will stand. National Assembly's Resolution Number 8 should neither prevent the filing of protest within the time prescribed in EC's resolution, nor toll the time in filing protest. Lerias versus HRET, the House of Electoral Tribunal. GR 97105. The best and most conclusive evidence to show the correctness of the number of votes involved are the ballots themselves. If the ballots are unavailable, the election returns are the next best evidence. Caution must be observed in rejecting election returns. Canvassing boards, the COMELEC and HRET, must only do so in cases where there is convincing proof that the returns are obviously manufactured or fake. Facts. Petitioner Rosette E. Lerias filed her certificate of candidacy as the official candidate of the UPP KBL for the position of representative for the Lone District of Southern Leyte in the May 11, 1987 elections. Respondent Roger G. Mercado was the administration candidate for the same position. During the canvass of votes for the congressional candidates by the Provincial Board of Canvassers of Southern Leyte, it appeared that excluding the certificate of canvass from the municipality of Libagon, which had been questioned by Mercado on the ground that allegedly it had been tampered with, the candidates who received the two highest number of votes were Roger D. Mercado with 34,000 votes and Rosette E. Lerias with 34,128 votes. Mercado had 34,442 votes. In the provincial board's copy of the certificate of canvass for the municipality of Libagon, Lerias received 1,811 votes while Mercado received 1,351. Thus, if said copy would be the one to be included in the canvass, Lerias would have received 35,939 votes as against Mercado's 35,793 votes, giving Lerias a winning margin of 146 votes. The COMELEC copy of the certificate of canvass was produced, and when opened, it showed that Lerias received only 1,411 votes in Libagon because in precincts 6, 10, 18, and 19, she received in each of the said precincts 100 votes less than what she received as shown in the Provincial Board of Canvassers copy of the certificate of canvass. Lerias filed with the COMELEC a petition for the annulment of the canvass and proclamation of Mercado, praying that the ballot boxes of precincts 6, 10, 18, and 19 of Libagon be ordered opened and the votes therein recounted. On June 21, 1987, she filed a motion to suspend the effects of the proclamation of Mercado. There being no action taken by the COMELEC on the said motion, and since the term of office of the members of the House of Representatives would commence on June 30, 1987, Lerias filed on June 30, 1987, before this court a petition for the annulment of the COMELEC resolution of June 6 and the proclamation of Mercado. On June 17, 1987, the COMELEC resolved to dismiss the case because the petitioner had filed a case with the Supreme Court and had therefore abandoned her case with the COMELEC. On June 22, 1987, Lerias filed with this court a second petition to set aside not only the COMELEC's resolution of July 6, 1987, but also the resolution of July 17, 1987. The court dismissed the petition because a. The COMELEC resolution of June 6, 1987 and the proclamation of Mercado had already become executory inasmuch as 5 days had elapsed from receipt of a copy of said resolution by petitioner and no restraining order had been issued by the court citing Section 246 of the Omnibus Election Code, and b. Lerias through counsel had agreed before the COMELEC Second Division during the hearing therein on June 5, 1987 to use the COMELEC copy of the certificate of canvass. Lerias filed a motion for reconsideration, but the same was denied. Hence, on October 1, 1987, she filed an election protest with respondent HRET. Conclusion. Considering the indubitable evidence and record, the 400 votes fraudulently taken away from Lerias should be returned to her, so that in the entire municipality of Libagon, she received 1,811 votes from the original 35,539 votes. Lerias should be credited with 35,939 votes as against the 35,793 votes of Mercado, giving her a margin of 146 votes. Whatever the results of the review of the ballots in the counter-protested precincts would be, wherein Mercado won by 67 votes according to the majority, or as found by the dissenting members, Lerias won by 12 votes, dissent of J. Herrera, or by 20 votes, dissent of Representative Ciriles. Lerias would still be the winner. Wherefore, the decision of the Honorable Electoral Tribunal in HRET case number 16 is reversed and set aside. The court declares the petitioner Rosette Iniguez Lerias is the duly elected representative of the Lone District of the province of Southern Leyte. Senate versus Ermita, GR 169777. Facts. This case is regarding the railway project of the North Luzon Railways Corporation with the China National Machinery and Equipment Group as well as the wiretapping activity of the ISAF-P and the fertilizer scam. The Senate committee sent invitations to various officials of the executive department and AFP officials for them to appear before Senate on September 29, 2005. Before said date arrived, Executive Secretary Ermita sent a letter to Senate President Drilon requesting for a postponement of the hearing on September 29 in order to afford said officials ample time and opportunity to study and prepare for the various issues so that they may better enlighten the Senate committee on its investigation. Senate refused the request. On September 28, 2005, the President issued EO 464, effective immediately, which among others mandated that all heads of department of the executive branch of the government shall secure the consent of the President prior to appearing before either House of Congress. Pursuant to this order, Executive Secretary Ermita communicated to the Senate that the executive and AFP officials would not be able to attend the meeting since the President has not yet given her consent. Despite the lack of consent, Colonel Balutan and Brigade General Gudani, among all the AFP officials invited, attended the investigation. Both faced court-martials for such attendance issue whether EO 464 contravenes the power of inquiry vested in Congress. Ruling, to determine the constitutionality of EO 464, the Supreme Court discussed the two different functions of the legislature, the power to conduct inquiries in aid of legislation and the power to conduct inquiry during question hour. Question hour. The power to conduct inquiry during question hours is recognized in Article 6, Section 22 of the 1987 Constitution, which reads, "The heads of the department may, upon their own initiative, with the consent of the President, or upon the request of either House, as the rules of each House shall provide, appear before and be heard by such House on any matter pertaining to their departments. Written questions shall be submitted to the President of the Senate or the Speaker of the House of Representatives at least 3 days before their scheduled appearance. Interpolations shall not be limited to written questions, but may cover matters related thereto, when the security of the state or the public interest so requires, and the President so states in writing. The appearance shall be conducted in executive session." The objective of conducting a question hour is to obtain information in pursuit of Congress oversight function. When Congress merely seeks to be informed on how department heads are implementing the statutes which it had issued, the department head's appearance is merely requested. The Supreme Court construed Section 1 of EO 464 as those in relation to the appearance of a department heads during question hours, as it explicitly referred in Section 22, Article 6 of the 1987 Constitution. In aid of legislation, the legislature's power to conduct inquiry in aid of legislation is expressly recognized in Article 6, Section 21 of the 1987 Constitution, which reads, "The Senate or the House of Representatives or any of its respective committees may conduct inquiries in aid of legislation in accordance with its duly published rules of procedure. The rights of persons appearing in or affected by such inquiries shall be respected. The power of inquiry in aid of legislation is inherent in the power to legislate. A legislative body cannot legislate wisely or effectively in the absence of information respecting the conditions which the legislation is intended to affect or change, and where the legislative body does not itself possess the requisite information, recourse must be had to others who do possess it. But even where the inquiry is in aid of legislation, there are still recognized exemptions to the power of inquiry, which exemption fall under the rubric of executive privilege. This is the power of the government to withhold information from the public, the courts, and the Congress. This is recognized only to certain types of information of a sensitive character. When Congress exercises power of inquiry, the only way for department heads to exempt themselves therefrom is by a valid claim of privilege. They are not exempt by the mere fact that they are department heads. Only one official may be exempted from this power, the President. Section 2 and 3 of EO 464 requires that all the public officials enumerated in Section 2B should secure the consent of the President prior to appearing before either House of Congress. The enumeration is broad. In view thereof, whenever an official invokes EO 464 to justify the failure to be present, such invocation must be construed as a declaration to Congress that the President or a head of office authorized by the President has determined that the requested information is privileged. The letter sent by the Executive Secretary to Senator Drilon does not explicitly invoke executive privilege, or that the matter on which these officials are being requested to be resource persons falls under the recognized grounds of the privilege to justify their absence. Nor does it expressly state that in view of the lack of consent from the President under EO 464, they cannot attend the hearing. The letter assumes that the invited official possesses information that is covered by the executive privilege. Certainly, Congress has the right to know why the executive considers the requested information privileged. It does not suffice to merely declare that the President or an authorized head of office has determined that it is so. The claim of privilege under Section 3 of EO 464 in relation to Section 2B is thus invalid per se. It is not asserted, it is merely implied. Instead of providing precise and certain reasons for the claim, it merely invokes EO 464 coupled with an announcement that the President has not given his/her consent. When an official is being summoned by Congress on a matter which, in his own judgment, might be covered by executive privilege, he must be afforded reasonable time to inform the President or the Executive Secretary of the possible need for invoking the privilege. This is necessary to provide the President or the Executive Secretary with fair opportunity to consider whether the matter indeed calls for a claim of executive privilege. If, after the lapse of that reasonable time, neither the President nor the Executive Secretary invokes the privilege, Congress is no longer bound to respect the failure of the official to appear before Congress, and may then opt to avail of the necessary legal means to compel his appearance. Wherefore, the petitioner partly granted, Section 2B and 3 of EO 464 are declared null void. Section 1, letter A, is however valid. Marcos versus Manglapus, GR 88211. Facts. Former President Ferdinand E. Marcos was deposed from the presidency by the nonviolent people power revolution and was forced into exile. Marcos, in his deathbed, has signified his wish to return to the Philippines to die, but President Corazon Aquino, considering the dire consequences of the nation of his return at a time when the stability of government is threatened from various directions and the economy is just beginning to rise and move forward, has stood firmly on the decision to bar the return of Marcos and his family. Aquino barred Marcos from returning due to possible threats and following supervening events. 1. Failed Manila Hotel coup in 1986, led by Marcos leaders. Channel 7 taken over by rebels and loyalists. Plan of Marcos's to return with mercenaries abroad. A chartered plane of a Lebanese arms dealer. This is to prove that they can steer trouble from afar. Honassan's failed coup. Communist insurgency movements. Secessionist movements in Mindanao. Devastated economy because of accumulated foreign debt. Plunder of nation by Marcos and cronies. Marcos filed for a petition of mandamus and prohibition to order the respondents to issue them their travel documents and prevent the implementation of President Aquino's decision to bar Marcos from returning in the Philippines. Petitioner questions Aquino's power to bar his return in the country. He also questioned the claim of the President that the decision was made in the interest of national security, public safety, and health. Petitioner also claimed that the President acted outside her jurisdiction. According to the Marcoses, such act deprives them of their right to life, liberty, property, without due process and equal protection of the laws. They also said that it deprived them of their right to travel, which according to Section 6, Article 3 of the Constitution, may only be impaired by a court order. Issue: whether or not, in the exercise of the powers granted by the Constitution, the President may prohibit the Marquesas from returning to the Philippines, whether or not the President acted arbitrarily or with grave abuse of discretion, amounting to lack or excess of jurisdiction, when she determined that the return of the Marquesas to the Philippines poses a serious threat to national interest and welfare, and decided to bar them their return. Decision: no to both issues. Petition dismissed. Ratio: separation of power dictates that each department has exclusive powers according to Section 1, Article 7 of the 1987 Philippine Constitution. The executive power shall be vested in the President of the Philippines. However, it does not define what is meant by executive power, although in the same article it touches on exercise of certain powers by the President. Example: the power of control over all executive departments, bureaus, and offices, the power to execute the laws, the appointing power to grant reprieves, commutation, and pardon. Although the Constitution outlines tasks of the President, this list is not defined and exclusive. She has residual and discretionary powers not stated in the Constitution, which include the power to protect the general welfare of the people. She is obliged to protect the people, promote their welfare, and advance national interests. Residual powers, according to Theodore Roosevelt, dictate that the President can do anything which is not forbidden in the Constitution. Inevitable to vest discretionary powers on the President, and that the President has to maintain peace during times of emergency, but also in the day-to-day operation of the state. The rights Marquesas are invoking are not absolute. They're flexible depending on the circumstances. The request of the Marquesas to be allowed to return to the Philippines cannot be considered in the light solely of the constitutional provisions guaranteeing liberty of abode and the right to travel, subject to certain exceptions, or of case law, which clearly never contemplated situations even remotely similar to the present one. It must be treated as a matter that is appropriately addressed to those residual unstated powers of the President, which are implicit in and relative to the paramount duty residing in that office to safeguard and protect general welfare. In that context, such request or demand should submit to the exercise of a broader discretion on the part of the President to determine whether it must be granted or denied. For issue number 2, the question for the court to determine is whether or not there exists factual basis for the President to conclude that it was in the national interest to bar the return of the Marquesas in the Philippines. It is proven that there are factual bases in her decision. The supervening events that happened before her decision are factual. The President must take preemptive measures for the self-preservation of the country and protection of the people. She has to uphold the Constitution. Though the right to return to one's country is not constitutionally protected, it is generally accepted principle of international law and thus a part of domestic law. It is not, however, an absolute right. Public interest grounds may limit it. Essentially, the right involved in the right to return to one's country, a totally distinct right under international law, independent from although related to the right to travel. Thus, the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights treat the right to freedom of movement and abode within the territory of a state, the right to leave a country, and the right to enter one's country as separate and distinct rights. The court allowed the government's ban on Marquez and his family's return. Mondano versus Silvosa, GR 7708. Facts: the Assistant Executive Secretary endorsed the complaint for rape and concubinage against Mondano, to an elected and qualified mayor of Mainit, Surigao, to Silvosa, provincial governor of Surigao, for immediate investigation, appropriate action, and report. Silvosa issued an administrative order suspending Mondano from office. Mondano filed a petition for prohibition enjoining the governor from further proceeding. Issue: whether or not the order of suspension by the provincial governor is illegal. Ruling: yes. The department head, as agent of the President, has direct control and supervision over all bureaus and offices under his jurisdiction as provided for in Section 79 of the Revised Administrative Code, but he does not have the same control of local governments as that exercised by him over bureaus and offices under his jurisdiction, and does not extend to local governments over which the President exercises only general supervision as may be provided by law. If the provisions of Section 79, letter C of the RAC are to be construed as conferring upon the corresponding department head direct control, direction, and supervision over all local governments, and that for that reason he may order the investigation of an official of a local government for malfeasance in office. Such interpretation would be contrary to the provisions of paragraph 1, section 10, article 7 of the 1935 Constitution. If general supervision over all local governments is to be construed as the same power granted to the department head in section 79 letter C of the RAC, then there would no longer be a distinction or difference between the power of control and that of supervision. Supervision overseeing or the power of or authority of an officer to see that subordinate officers perform their duties. Control, power of an officer to alter or modify or nullify or set aside what the subordinate officer had done in the performance of duties and to substitute the judgment of the former for that of the latter. Such is the import of the provisions of section 79 of RAC. Issue: whether the endorsement of the complaint by the Assistant Executive Secretary to the respondent is legal. Held: yes, because the heads of various executive departments are agents of the President who constitutionally have general supervision over local governments as may be provided by law. Supervision in administrative law means overseeing or the power of authority of an official to see that subordinate officers perform their duties. The respondent governor, upon the endorsement of the Assistant Executive Secretary, is only acting as an agent of the President in investigating the petitioner. Held from the full case. In the endorsement of the provincial governor, the Assistant Executive Secretary requested immediate investigation, appropriate action, and report on the complaint endorsed to him, and called his attention to Section 2193 of the Revised Administrative Code, which provides for the institution of judicial proceeding by the provincial fiscal upon direction of the provincial governor. If the endorsement of the Assistant Executive Secretary be taken as a designation of the provincial governor to investigate the petitioner, then he would only be acting as agent of the executive, but the investigation to be conducted by him would not be that which is provided for in sections 2188, 2189, 2119, 2190 of the Revised Administrative Code. The charges preferred against the respondent are not malfeasance or any of those enumerated or specified in section 2188 of the Revised Administrative Code, because rape and concubinage have nothing to do with the performance of his duties as mayor, nor do they constitute or involve neglect of duty, oppression, corruption, or any other form of maladministration of office. True, they may involve moral turpitude, but before the provincial governor and board may act and proceed in accordance with the provisions of the Revised Administrative Code referred to, a conviction by final judgment must precede the filing by the provincial governor of charges and trial by the provincial board. Even the provincial fiscal cannot file an information for rape without the sworn complaint of the offended party, who is 28 years of age, and the crime of concubinage cannot be prosecuted but upon sworn complaint of the offended spouse. The charges preferred against the petitioner, municipal mayor of Mainit, province of Surigao, not being those or any of those specified in the section 2188 of the Revised Administrative Code, the investigation of such charges by the provincial board is unauthorized and illegal. The suspension of the petitioner as mayor of the municipality of Mainit is consequently unlawful and without authority of law. The writ of prohibition prayed for is granted without pronouncement as to costs. Lacson Magallanes versus Puno. Facts: 1932. Jose Magallanes was a permittee and actual occupant of a 1,103-hectare pasture land situated in Tamlangon municipality of Bansalan, province of Davao. January 9, 1953, Magallanes ceded his rights and interest to a portion of the above public land to plaintiff. April 13, 1954, the portion Magallanes ceded to plaintiff was officially released from the forest zone as pasture land and declared agricultural land. January 26, 1955, Jose Paño and 19 other claimants applied for the purchase of 90 hectares of the released area. March 29, 1955, Plaintiff Corporation in turn filed its own sales application covering the entire released area. This was protested by Jose Paño and his 19 companions upon the averment that they are actual occupants of the part thereof covered by their own sales application. July 31, 1956, the Director of Lands, following an investigation of the conflict, rendered a decision on giving due course to the application of Plaintiff Corporation and dismissing the claim of Jose Paño and his companions. A move to reconsider failed. July 5, 1957, the Secretary of Agriculture and Natural Resources, on appeal by Jose Paño for himself and his companions, held that the appeal was without merit and dismissed the case. June 25, 1958, Executive Secretary Juan Pajo, by authority of the President, decided the controversy, modified the decision of the Director of Lands as affirmed by the Secretary of Agriculture and Natural Resources, and number 1, declared that it would be for the public interest that appellants, who are mostly landless farmers who depend on the land for their existence, be allocated that portion on which they have made improvements, and number 2, directed that the controverted land, northern portion of Block 1 LC Map 1749, Project number 27 of Bansalan, Davao, with Latian River as the dividing line, should be subdivided into lots of convenient sizes and allocated to actual occupants without prejudice to the corporation's right to reimbursement for the cost of surveying this portion. Plaintiff Corporation took the foregoing decision to the Court of First Instance, praying that judgment be rendered, declaring 1. That the decision of the Secretary of Agriculture and Natural Resources has full force and effect, and 2. That the decision of the Executive Secretary is contrary to law and no legal force and effect. Issue: whether or not the Executive Secretary, acting by authority of the President, reversed a decision of the Director of Lands that had been affirmed by the Executive Secretary of Agriculture and Natural Resources, yielded an affirmative answer from the lower court. Held: judgment on the review is hereby affirmed. Executive Secretary's act cannot be assailed and therefore has full force and effect. Plaintiff's position is incorrect. The President's duty to execute the law is of constitutional origin. So, too, is his control of all executive departments. Thus, it is that department heads are men of his confidence. His is the power to appoint them. His, too, is the privilege to dismiss them at pleasure. Naturally, he controls and directs their acts. Implicit, then, is his authority to go over, confirm, modify, or reverse the action taken by his department secretaries. In this context, it may not be said that the President cannot rule on the correctness of a decision of a department secretary, particularly in reference to the decisions of the Director of Lands as affirmed by the Secretary of Agriculture and Natural Resources. The standard practice is to allow appeals from such decisions to the office of the President. This court has recognized this practice in several cases. In one, the decision of the Lands Director as approved by the Secretary was considered superseded by that of the President's appeal. In other cases, failure to pursue or resort to this last remedy of appeal was considered a fatal defect, warranting dismissal of the case for non-exhaustion of all administrative remedies. Parenthetically, it may be stated that the right to appeal to the President reposes upon the President's power of control over the executive department, and control simply means the power of an officer to alter or modify or nullify or set aside what a subordinate officer had done in the performance of his duties, and to substitute the judgment of the former for that of the latter. This unquestionably negates the assertion that the President cannot undo or an act of his department secretary. Plaintiffs next submit the decision of the executive secretary herein is an undue delegation of power. The Constitution, petitioner asserts, does not contain any provision whereby the presidential power of control may be delegated to the executive secretary. It is argued that it is the constitutional duty of the President to act personally upon the matter. It is correct to say that constitutional powers there are which the President must exercise in person. Not as correct, however, it is to say that the chief executive may not delegate to his executive secretary acts which the Constitution does not command that he perform in person. Reason is not wanting for this view. The President is not expected to perform in person all the multifarious executive and administrative functions. The office of the Executive Secretary is an auxiliary unit which assists the President. The rule which has thus gained a recognition is that under our constitutional setup, the Executive Secretary, who acts for and in behalf and by authority of the President, has an undisputed jurisdiction to affirm, modify, or even reverse any order that the Secretary of Agriculture and Natural Resources, including the Director of Lands, may issue. But plaintiff underscores the fact that the Executive Secretary is equal in rank to the other department heads, no higher than any one of them. From this, plaintiff carves the argument that one department head, on the pretext that he is an alter ego of the President, cannot intrude into the zone of action allocated to another department secretary. This argument betrays lack of appreciation of the fact that where, as in this case, the Executive Secretary acts by authority of the President, his decision is that of the President. Such decision is to be given full faith and credit by our courts. The assumed authority of the Executive Secretary is to be accepted, for only the President may rightfully say that the Executive Secretary is not authorized to do so. Therefore, unless the action taken is disapproved or reprobated by the Chief Executive, that remains the act of the Chief Executive and cannot be successfully assailed. So no such disapproval or reprobation is even intimated in the record of this case. Ernesto Maceda versus Catalino Macaraeg. This is digested by Shen Hashi, blogspot.com. Facts. On November 3, 1986, Commonwealth Act No. 120 created the NPC as a public corporation to undertake the development of hydraulic power and the production of power from other sources. On June 4, 1949, Republic Act No. 358 granted NPC tax and duty exemption privileges, exempt from all taxes, duties, fees, imposts, charges, and restrictions of the Republic of the Philippines, its provinces, cities, and municipalities. On January 22, 1974, Presidential Decree No. 380 amended it. The exemption of NPC from such taxes, duties, fees, imposts, and other charges imposed directly or indirectly on all petroleum products used by NPC in its operation. On June 11, 1984, Presidential Decree No. 1931 withdrew all tax exemption privileges granted in favor of government-owned and or controlled corporations, including their subsidiaries. However, said law empowered the President and or the then Minister of Finance, upon recommendation of the FIRB, to restore, partially or totally, the exemption withdrawn or otherwise revise the scope and coverage of any applicable tax and duty. On January 7, 1986, the FIRB issued Resolution No. 1-86 indefinitely restoring the NPC tax and duty exemption privileges effective July 1, 1985. However, effective March 10, 1987, Executive Order No. 93 once again withdrew all tax and duty incentives granted to government and private entities, which had been restored under Presidential Decree Numbers 1931 and 1955, but it gave authority to FIRB to restore, revise the scope, and prescribe the date of effectivity of such tax and or duty exemptions. On June 24, 1987, the FIRB issued Resolution No. 17-87, restoring NPC's tax and duty exemption privileges effective March 10, 1987. Issues: whether petitioner have the standing to challenge the questioned orders and resolution, whether or not the respondent NPC has ceased to enjoy indirect tax and duty exemption with the enactment of PD No. 938 on March 27, 1976, which amended PD No. 380 issued on January 11, 1974. Ruling. First issue, petitioner as a taxpayer may file the instant petition following the ruling in Losada when it involves illegal expenditure of public money. The petition questions the legality of the tax refund to NPC by way of tax credit certificates and the use of said assigned tax credits by respondent oil companies to pay for their tax and duty liabilities to the BIR and Bureau of Customs. Difference between direct tax and indirect tax. A direct tax is a tax for which a taxpayer is directly liable in the transaction or business it engages in. Examples are the custom duties and ad valorem taxes paid by the oil companies to the Bureau of Customs for the importation of crude oil, and the specific and ad valorem taxes they pay to the Bureau of Internal Revenue after converting the crude oil into petroleum products. On the other hand, indirect taxes are taxes primarily paid by persons who can shift the burden upon someone else. For example, the excise and ad valorem taxes that oil companies pay to the Bureau of Internal Revenue upon removal of petroleum products from its refinery can be shifted to its buyer, like the NPC, by adding them to the cash and or selling price. Second issue, it is noted that in the earlier law, RA number 358, the exemption was worded in general terms as to cover all taxes, duties, fees, imposed charges, etc. However, the amendment under Republic Act No. 6395 enumerated the details covered by the exemption. Subsequently, PD No. 380 made even more specific the details of the exemption of NPC to cover, among others, both direct and indirect taxes on all petroleum products used in its operation. Presidential Decree No. 938 amended the tax exemption by simplifying the same law in general terms. It succinctly exempts NPC from all forms of taxes, duties, fees imposed, as well as cost and service fee, including filing fees, appeal bonds, supersedeas bonds in any court or administrative proceedings. The use of the phrase all form of taxes demonstrates the intention of the law to give NPC all the tax exemption it has been enjoying before. The rationale for this exemption is that being non-profit, the NPC shall devote all its returns from its capital investment as well as excess revenues from its operation for expansion. Petitioner cannot invoke the rule in strictissimi juris with respect to the interpretation of statutes granting tax exemption to NPC. Moreover, it is recognized principle that the rule in strict interpretation does not apply in the case of exemptions in favor of a government political subdivision or instrumentality. Alexander Padilla et al. Versus Congress of the Philippines, GR 231671, digest from Lawyerly. Facts. Resolutions separately passed by the Senate and the House of Representatives, which express support as well as the intent not to revoke President Duterte's Proclamation No. 216, endures their right to a proper and mandatory legislative review of the declaration of martial law, and that the continuing failure of the Congress to convene in joint session similarly causes a continuing injury to their rights. Senator De Lima adds that she, together with the other senators who voted in favor of the resolution to convene the Congress jointly, were even effectively denied the opportunity to perform their constitutionally mandated duty under Article 7, Section 18 of the Constitution to deliberate on the said proclamation of the President in a joint session of the Congress. Congress is required to convene in joint session to review Proclamation No. 216 and vote as a single deliberative body. May revoke such proclamation or suspension under Article 7, Section 18 of the Constitution allegedly pertain to the power of the Congress to revoke, but not to its obligation to jointly convene and vote, which they stress is mandatory. The convening of the Congress in joint session, whenever the President declares martial law or suspends the privilege of the writ of habeas corpus, is a public right and duty mandated by the Constitution issues. Whether or not under Article 7, Section 18 of the 1987 Constitution, it is mandatory for the Congress to automatically convene in joint session in the event that the President proclaims a state of martial law and or suspends the privilege of the writ of habeas corpus in the Philippines or any part thereof. Ruling, the court acknowledges that the main relief prayed for in the present petition, example that the Congress be directed to convene in joint session and therein deliberate whether to affirm or revoke Proclamation No. 216, may arguably have been rendered moot by a. the lapse of the original 60 days, that the President martial law declaration and suspension of the privilege of the writ of habeas corpus were effective under Proclamation No. 216, b. the subsequent extension by the Congress of the proclamation of martial law and the suspension of the privilege of the writ of habeas corpus over the whole of Mindanao after convening in joint session on July 22nd, 2017, and c. the court's own decision in Lagman versus Medialdia, wherein we ruled on the sufficiency of the factual basis for Proclamation Number 216 under the original period stated therein. These cases involve a constitutional issue of transcendental significance and novelty. First provision was complied with, as within 48 hours from the issuance of May 23, 2017 by President Duterte of Proclamation Number 216 declaring a state of martial law and suspending the privilege of the writ of habeas corpus in Mindanao. Copies of President Duterte's report relative to Proclamation Number 216 was transmitted to and received by the Senate and the House of Representatives on May 25, 2017. Principles. The Congress is not constitutionally mandated to convene in joint session except to vote jointly to revoke the President's declaration of suspension. In its literal and ordinary meaning, the provision grants the Congress the power to revoke the President's proclamation of martial law or the suspension of the privilege of the writ of habeas corpus and prescribe how the Congress may exercise such power. Example, by vote of at least a majority of all its members voting jointly in a regular or special session. The use of the word may in the provision is to be construed as permissive and operating to confer discretion on the Congress on whether or not to revoke. But in order to revoke, the same provision sets the requirement that at least a majority of the members of the Congress voting jointly favor revocation. The provision does not actually refer to a joint session. Here, the requirement that Congress voting jointly by a vote of at least a majority of all its members in regular or special session explicitly applies only to the situation when the Congress revokes the President's proclamation of martial law and or suspension of the privilege of writ of habeas corpus. The result of the foregoing, the 1987 Constitution does not provide at all for the manner of determination and expression of concurrence, whether prior or subsequently, by the Congress in President's proclamation of martial law and or suspension of the privilege of the writ of habeas corpus. The underlying reason for the requirement that the two houses of the Congress will vote jointly is to avoid the possibility of a deadlock and to facilitate the process of revocation of the President's proclamation of martial law and or suspension of the privilege of writ of habeas corpus. At present, the Commander-in-Chief still possesses the power to suspend the privilege of the writ of habeas corpus and to proclaim martial law. However, these executive powers are now subject to the review of both the legislative and judicial branches. This check and balance mechanism was installed in 1987 Constitution precisely to prevent potential abuses of these executive prerogatives. Inasmuch as the present petitions raise issues concerning the Congress' role in our government system of checks and balances, these are matters of paramount public interest or issues of transcendental importance deserving the attention of the court in view of their seriousness, novelty, and weight of precedent. On the issue whether or not under Article 7, Section 18 of the Constitution is it mandatory for the Congress to automatically convene in joint session in the event that the President proclaims a state of martial law and or suspend the privilege of writ of habeas corpus in the Philippines and or any part thereof, the court answers in the negative. The Congress is not constitutionally mandated to convene in joint session except to vote jointly to revoke the President's declaration or suspension. Tanada versus Congress. Similar to the contention in Padilla petition, petitioners maintain that they have sufficiently shown all the essential requisites in order for this court to exercise its power of judicial review, in that number 1, an actual case or controversy exists. 2, they possess the standing to file this case. Number 3, the constitutionality of a governmental act has been raised at the earliest possible opportunity. And 4, the constitutionality of said act is the very lis mota of the petition. According to petitioners, there is an actual case or controversy because the failure and or refusal of the Congress to convene jointly deprived legislators of a venue within which to raise a motion for revocation or even extension of President Duterte's proclamation number 216 and the public of an opportunity to be properly informed as to the basis and particular thereof. Petitioners likewise claim to have legal standing to sue as citizens and taxpayers. Nonetheless, they submit that the present case calls for the court's liberality in the appreciation of their locus standi, given the fact that their petition presents a question of first impression, one of paramount importance to the future of our democracy as well as the extraordinary nature of martial law itself. Petitioners contend that the convening of the Congress in joint session whenever the President declares martial law or suspends the privilege of the writ of habeas corpus is a public right and duty mandated by the Constitution. The writ of mandamus is thus the proper recourse for citizens who seek to enforce a public right and to compel the performance of a public duty, especially when the public right involved is mandated by the Constitution. For this group of petitioners, the members of the Congress gravely abused their discretion for their refusal to convene in joint session, underscoring that while a writ of mandamus will not generally lie from one branch of the government to a coordinate branch or to compel the performance of a discretionary act, this admits a certain exceptions, such as in instances of gross abuse of discretion, manifest injustice, or palpable excess of authority, when there is no other plain, speedy, and adequate remedy. As to the merits, petitioners assert that the convening of the Congress in joint session after the declaration of martial law is mandatory under Article 7, Section 18 of the Constitution, whether or not the Congress is in session or there is intent to revoke. It is their theory that a joint session should be a deliberate process in which, after debate and discussion, legislators can come to an informed decision as to the factual and legal basis of the declaration of martial law. Moreover, legislators who wish to revoke the martial law proclamation should have the right to put the vote on historical record in joint session, and in like manner the public should have the right to know the position of their legislators with respect to this matter of the highest national interest. Petitioners add that a public, transparent, and deliberate process is purportedly necessary to allay the people's fear against executive overreach. This concern allegedly cannot be addressed by briefings in executive sessions given by representatives of the executive branch to both houses of the Congress. Respondents Congress assert firmly that there is no mandatory duty of their part to vote jointly, except in cases of revocation or extension of the proclamation of martial law or the suspension of the privilege of the writ of habeas corpus. In the absence of such duty, the non-convening of the Congress in joint session does not pose any actual case or controversy that may be the subject of judicial review. Additional respondents argue that the petition raised a political question over which the court has no jurisdiction. Respondents further contend that the constitutional right to information is enshrined under Article 3, Section 7 of the Constitution is not absolute. Matters affecting national security are considered as a valid exemption to the right to information of the public. For this reason, the petitioners and the public's right to participate in the deliberations of the Congress regarding the factual basis of a martial law declaring may be restricted in the interest of national security and public safety. Respondents allege that petitioners failed to present an appropriate case for mandamus to lie. Mandamus will only issue when the act to be compelled is a clear legal duty or a ministerial duty imposed by law upon the defendant or respondent to perform the act required that the law specifically enjoins as a duty resulting from office, trust, or station. According to respondents, it is erroneous to assert that it is their ministerial duty to convene in joint session whenever martial law is proclaimed, or the privilege of the writ of habeas corpus is suspended in the absence of a clear and specific constitutional or legal provision. In fact, Article 7, Section 18 does not use the word joint session at all, much less impose the convening of such joint session upon the proclamation of martial law or the suspension of the privilege of the writ of habeas corpus. What the Constitution requires is joint voting when the action of the Congress is to revoke or extend the proclamation or suspension. Indeed, prior concurrence of the Congress is not constitutionally required for the effectivity of the proclamation or suspension. Quoting from the deliberations of the framers of the Constitution pertaining to Article 7, Section 18, the Congress points out that it was the intention of the said framers to grant the President the power to declare a martial law or suspend the privilege of the writ of habeas corpus for a period of not exceeding 60 days. Without the concurrence of the Congress, there is absolutely nothing under the Constitution that mandates the Congress to convene in joint session when their intention is merely to discuss, debate, or to review the factual and legal basis for the proclamation. That is why the phrase voting jointly is limited only in case the Congress intends to revoke the proclamation. In a situation where the Congress is not in session, the Constitution simply provides the Congress must convene in accordance with its rules but does not state that it must convene in joint session. Respondents further refer to the proper procedure for the holding of joint session. Lagman versus Medialtia, Lagman's petition. Lagman's petition claims that the declaration of martial law has no sufficient factual basis because there is no rebellion or invasion in Marawi City or in any part of Mindanao. It argues that acts of terrorism in Mindanao do not constitute rebellion since there is no proof that its purpose is to remove Mindanao or any part thereof from allegiance to the Philippines, its laws, or its territories. It labels the flying of ISIS flag by the Maute group in Marawi City and other outlying areas as mere propaganda one, and not an open attempt to remove such areas from the allegiance to the Philippine government and deprive the chief executive of the assertion and exercise of his powers and prerogatives therein. It contends that the Maute group is a mere private army, citing as basis the alleged interview of Vera files with Joseph Franco, wherein the latter allegedly mentioned that the Maute group is more of a clan's private militia latching into the IS brand theatrically to inflate perceived capability. The Lagman petition insists that during the briefing, representatives of the military and defense authorities did not categorically admit nor deny the presence of an ISIS threat in the country, but they merely gave an evasive answer that there is ISIS in the Philippines. The Lagman petition also avers that Lieutenant General Salvador Mison Jr. himself admitted that the current armed conflict in Marawi City was precipitated or initiated by the government in its bid to capture Hapilon. It concludes that the objective of the Maute group's armed resistance was merely to shield Hapilon and the Maute brothers from the government forces and not to lay siege on Marawi City and remove its allegiance to the Philippine Republic. It then posits that if at all there is only a threat of a rebellion in Marawi City, which is akin to imminent danger of rebellion, which is no longer a valid ground for the declaration of martial law. To recall, the court held in the 1951 case of Montenegro versus Castaneda that the authority to decide whether there is a state of rebellion requiring the suspension of the privilege of the writ of habeas corpus is lodged with the President, and his decision thereon is final and conclusive upon the courts. This ruling was reversed in the 1971 case of Lansang, where it was held that the factual basis of the declaration of martial law and the suspension of the privilege of writ of habeas corpus is not a political question and is within the ambit of judicial review. However, in 1983, or after the declaration of martial law by former President Ferdinand E. Marcos, the court in Garcia Padilla versus Enrile abandoned the ruling in Lansang and reverted to Montenegro. According to the Supreme Court, the constitutional power of the President to suspend the privilege of writ of habeas corpus is not subject to judicial inquiry. Thus, by inserting Section 18 in Article 7, which allows judicial review of the declaration of martial law and suspension of the privilege of writ of habeas corpus, the framers of 1987 in effect constitutionalized and reverted to the Lansang doctrine. Among the three extraordinary powers of the President, the calling out power is the most benign and involves ordinary police action. The President may resort to this extraordinary power whenever it becomes necessary to prevent or suppress lawless violence, invasion, or rebellion. The power to call is fully discretionary to the President, the only limitations being that he acts within permissible constitutional boundaries or in a manner not constituting grave abuse of discretion. In fact, the actual use to which the President puts the armed forces is not subject to judicial review. The framers of the 1987 Constitution eliminated insurrection and the phrase imminent danger thereof as grounds for the suspension of the privilege of the writ of habeas corpus or declaration of martial law. They perceived the phrase imminent danger to be fraught with possibilities of abuse. Besides, the calling out power of the President is sufficient for handling imminent danger. The powers to declare martial law and to suspend the privilege of the writ of habeas corpus involve curtailment and suppression of civil rights and individual freedom. Thus, the declaration of martial law serves as a warning to citizens that the executive department has called upon the military to assist in the maintenance of law and order, and while the emergency remains, the citizens must, under pain of arrest and punishment, not act in a manner that will render it more difficult to restore order and enforce the law. As such, their exercise requires more stringent safeguards by the Congress and review by the court. Barioquinto versus Fernandez. Facts: Petitioners Jimenez and Barioquinto were charged with the crime of murder. Jimenez was sentenced to life imprisonment while Barioquinto remained at large. Before the period for appeal had expired, Jimenez became aware of the Proclamation Number 8, which grants amnesty in favor of all persons who may be charged with an act penalized under the revised penal code, in furtherance of the resistance to the enemy or against person aiding in war efforts of the enemy, and committed during the period from December 8, 1941 to the date when particular area of the Philippines where the offense was actually committed was liberated from enemy control and occupation. Jimenez decided to apply for amnesty. Barioquinto, who had then been already apprehended, did the same. The Amnesty Commission returned the cases of the petitioners to the Court of First Instance Zamboanga without deciding on the case, saying that since the Barioquinto and Jimenez deny having committed the crime, they cannot invoke the benefits of amnesty issue. Is admission of guilt necessary in amnesty held? The theory of the respondent, supported by the dissenting opinion, is predicated on a wrong conception of the nature or character of an amnesty. Amnesty must be distinguished from pardon. Pardon is granted by the chief executive, and as such it is a private act which must be pleaded and proved by the person pardoned, because the courts take no notice thereof, while amnesty by proclamation of the chief executive with the concurrence of Congress, and it is a public act of which the courts should take judicial notice. Pardon is granted to one after conviction, while amnesty is granted to classes of persons or communities who may be guilty of political offenses, generally before or after the institution of the criminal prosecution, and sometimes after conviction. Pardon looks forward and relieves the offender from the consequences of an offense of which he has been convicted. That is, it abolished or forgives the punishment, and for that reason it does nor work the restoration of the rights to hold public office, or the rights of suffrage, unless such rights be expressly restored by the terms of the pardon, and it in no case exempts the culprit from the payment of civil indemnity imposed upon him by the sentence, while amnesty looks backward and abolishes and puts into oblivion the offense itself. It so overlooks and obliterates the offense with which he is charged that the person released by amnesty stands before the law precisely as though he had committed no offense. In order to entitle a person to the benefits of the Amnesty Proclamation of September 7, 1946, it is not necessary that he should, as a condition precedent or sine qua non, admit having committed the criminal act or offense with which he is charged and allege the amnesty as a defense. It is sufficient that the evidence either of the complainant or the accused shows that the offense committed comes within the terms of said amnesty proclamation. Hence, it is not correct to say that invocation of the benefits of amnesty is in the nature of a plea of confession and avoidance. Although the accused does not confess the imputation against him, he may be declared by the courts or the Amnesty Commissions entitled to the benefits. For whether or not he admits or confesses having committed the offense with which he is charged, the Commission should, if necessary or requested by the interested party, conduct summary hearing of the witnesses both for the complainant and the accused, on whether he has committed the offense in furtherance of the resistance to the enemy or against persons aiding in the war efforts of the enemy, and decide whether he is entitled to the benefits of amnesty and to be regarded as a patriot or hero who have rendered invaluable services to the nation, or not, in accordance with the terms of the Amnesty Proclamation. Since the Amnesty Proclamation is a public act, the courts as well as the Amnesty Commissions created thereby should take notice of the terms of said proclamation and apply the benefits granted therein to cases coming within their province or jurisdiction, whether pleaded or claimed by the person charged with such offenses or not, if the evidence presented show that the accused is entitled to said benefits. Monsanto versus Factoran. Facts. The Sandigan Bayan convicted petitioner Salvacion Monsanto, then Assistant Treasurer of Calbayog City, of the crime of estafa through falsification of public documents. She was sentenced to jail and to indemnify the government in the sum of 4,892 pesos and 50 cents. The Supreme Court affirmed the decision. She then filed a motion for reconsideration, but while said motion was pending, she was extended by then President Marcos absolute pardon, which she accepted. At that time, the rule was that clemency could be given even before conviction. By reason of said pardon, petitioner wrote the Calbayog City Treasurer requesting that she be restored to her former post as Assistant City Treasurer, since the same was still vacant. Her letter was referred to the Minister of Finance, who ruled that she may be reinstated to her position without the necessity of a new appointment, not earlier than the date she was extended to absolute pardon. Petitioner wrote the minister stressing that the full pardon bestowed on her has wiped out the crime, which implies that her service in the government has never been interrupted, and therefore the date of her reinstatement should correspond to the date of her preventive suspension, that she is entitled to back pay for the entire period of her suspension, and that she should not be required to pay the proportionate share of the amount of 4,892 pesos and 50 cents. The ministry referred the issue to the Office of the President. Deputy Executive Secretary Factoran denied Mosanto's request, averring that Mosanto must first seek appointment and that the pardon does not reinstate her former position. Issues: is Mosanto entitled to back pay? Number 1. Number 2. Is a public officer who has been granted an absolute pardon by the Chief Executive entitled to reinstatement to her former position without the need of a new appointment? 3. May petitioner be exempt from the payment of the civil indemnity imposed upon her by the sentence held? Pardon is defined as an act of grace proceeding from the power entrusted with the execution of the laws, which exempts the individual on whom it is bestowed from the punishment the law inflicts for a crime he has committed. It is the private, though official act of the executive magistrate delivered to the individual for whose benefit it is intended, and not communicated officially to the court. While a pardon has generally been regarded as blotting out the existence of guilt, so that in the eye of the law the offender is as innocent as though he never committed the offense, it does not operate for all purposes. The very essence of a pardon is forgiveness or remission of guilt. Pardon implies guilt. It does not erase the fact of the commission of the crime and the conviction thereof. It does not wash out the moral stain. It involves forgiveness and not forgetfulness. A pardon looks to the future. It is not retrospective. It makes no amends for the past. It affords no relief for what has been suffered by the offender. It does not impose upon the government any obligation to make reparation for what has been suffered. Since the offense has been established by judicial proceedings, that which has been done or suffered while they were in force is presumed to have been rightfully done and justly suffered, and no satisfaction for it can be required. This would explain why petitioner, though pardoned, cannot be entitled to receive back pay for lost earning and benefits. Number 2. The pardon granted to petitioner has resulted in removing her disqualification from holding public employment, but it cannot go beyond that. To regain her former post as Assistant City Treasurer, she must reapply and undergo the usual procedure required for a new appointment. Number 3. Civil liability arising from crime is governed by the revised penal code. It subsists notwithstanding service of sentence, or for any reason the sentence is not served by pardon, amnesty, or commutation of sentence. Petitioner's civil liability may only be extinguished by the same causes recognized in the Civil Code, namely payment, loss of the thing due, remission of the debt, merger of the rights of creditor and debtor, compensation, and novation. Vinuya versus Executive Secretary et al. Romulo. The petitioners were members of the non-governmental organization Malaya Lolas, acting on behalf of the so-called comfort women, who during World War II in December 1937 were kidnapped from their homes by Japanese soldiers. They were brought to barracks-like buildings where they had to live, and where they were repeatedly beaten, raped, and abused. During that time, the young women were forced to have sex with as many as 30 Japanese soldiers per day. The petitioners filed a case asking for support from the Philippine government in their action against Japan, who had previously rejected claims for compensation. The Supreme Court of the Philippines, however, refused to oblige the government to provide that support. Prior to the proceedings in the Philippines, a petition was filed before Japanese court for compensation. The petition was dismissed because the court ruled that the comfort women did not have personality under international law. According to the Japanese court, the claims of the comfort women had to be supported by the Philippines. On December 4, 2001, the Women's International War Crimes Tribunal on Japan's military sexual slavery, a people's tribunal established by Asian women, human rights organizations, and international NGOs, rendered its final judgment. The tribunal found that the comfort system was designed and maintained to facilitate the rape and sexual slavery of tens of thousands of young girls and women from occupied or conquered territories in the Asia-Pacific region in order to facilitate the war effort. As the scale of the comfort system was so widespread and organized, no other conclusion could be reached than that it was state-sanctioned rape and enslavement. In 2004, as a result, the non-governmental organization NGO Malaya Lolas filed a case before the Philippine Supreme Court on behalf of 70 Filipino comfort women to compel the Philippine government to support their claims for compensation from Japan. The Korean Constitutional Court, ruling on a petition with the same issues as those before the Philippine Supreme Court, ruled that Korea must espouse the claim of the Korean comfort women. This case concerns the petition filed by Malaya Lolas, an NGO acting on behalf of victims of rape in the Philippines committed by Japanese military forces during World War II. In particular, in the period between 1937 and 1945, an estimated number of 200,000 young Asian women were abducted from their homes by the Japanese imperial forces and were forced to serve as sex slaves, also known as comfort women, for more than 2 million Japanese soldiers and officers. The petitioners claimed that the comfort women system established by Japan and the brutal rape and enslavement of the comfort women constituted a crime against humanity, sexual slavery, and torture. They alleged that the Philippine government breached its obligation not to afford impunity for crimes against humanity by waiving the claims of Filipino comfort women and failing to espouse their complaints against Japan. The petition on behalf of the group of comfort women sought to compel the Philippine government to demand official apology and seek reparations from the Japanese government, in particular before the International Courts of Justice. Was the general waiver of claims made by the Philippine government in the Treaty of Peace with Japan void? Was the Philippine government acceptance of the apologies made by Japan contrary to international law? Did the Executive Department commit grave abuse of discretion in not espousing petitioners' claim for official apology and other forms of reparation against Japan? Courts holding an analysis. In a heavily criticized decision, the Supreme Court of the Philippines dismissed the petition for lack of merit. The court held that it was the executive that had exclusive power to espouse the petitioner's claim. The executive had already decided to waive all claims of its nationals against the Japanese government in the 1951 Treaty of Peace Act. The court held that it does not have the power to question the decision. Furthermore, the court declared that despite its sympathy for the victims, it was not within its power to order the executive to take up the petitioner's claim. The court held that to overturn the executive department's determination would mean an assessment of the foreign policy judgment by a coordinate political branch to which authority to make that judgment has been constitutionally committed. The court further declared that the Philippine government is not under any international obligation to espouse petitioner's claim. The court explained that an individual can only bring a claim within the international legal system when a government will bring a claim on behalf of the individual. Therefore, it is the state's discretionary power to decide whether and to what extent it offers diplomatic protection to an individual. The court affirmed that rape, sexual slavery, torture, and sexual violence are morally reprehensible as well as legally prohibited under contemporary international law, but stated that the practice of states does not yet support the present existence of an obligation to prosecute international crimes. Undoubtedly frustrated by the failure of litigation before Japanese courts, victims of the comfort women system brought their claims before the United States on September 18, 2000. 15 comfort women filed a class action lawsuit in the U.S. District Court for the District of Columbia, seeking money damages for allegedly having been subjected to sexual slavery and torture before and during World War II, in violation of both positive and customary international law. The case was filed pursuant to the Alien Tort Claims Act, ACTA, which allowed the plaintiff to sue the Japanese government in a U.S. federal district court. On October 4, 2001, the district court dismissed the lawsuit due to lack of jurisdiction over Japan, stating that there is no question that this court is not the appropriate forum in which plaintiff may seek to reopen discussion nearly half a century later. Even if Japan did not enjoy sovereign immunity, plaintiffs' claims are non-justiciable and must be dismissed. The District of Columbia Court of Appeals affirmed the lower court's dismissal of the case. On appeal, the U.S. Supreme Court granted the women's petition for writ of certiorari, vacated the judgment of the District of Columbia Court of Appeals, and remanded the case. On remand, the Court of Appeals affirmed its prior decision, noting that much as we may feel for the plight of the appellants, the courts of the U.S. simply are not authorized to hear their case. The women again brought their case to the U.S. Supreme Court, which denied their petition for writ of certiorari on February 29, 2006. Efforts at the United Nations. In 1992, the Korean Council for the Women drafted for military sexual slavery by Japan submitted a petition to the UN Human Rights Commission, UNHRC, asking for assistance in investigating crimes committed by Japan against Korean women and seeking reparation for former comfort women. The UNHRC placed the issue on its agenda and appointed Radhika Kumaraswamy as the issue's special investigator. In 1996, Kumaraswamy issued a report reaffirming Japan's responsibility in forcing Korean women to act as sex slaves for the Imperial Army. It made the following recommendation: that the government of Japan should acknowledge that the system of comfort stations set up by the Japanese Imperial Army during the Second World War was a violation of its obligation under international law and accept legal responsibility for that violation. Pay compensation to individual victims of Japanese military sexual slavery according to principle outlined by the Special Rapporteur of the Subcommission on Prevention of Discrimination and Protection of Minorities on the right to restitution, compensation, and rehabilitation for victims of grave violation of human rights and fundamental freedoms. A special administrative tribunal for this purpose should be set up with a limited time frame since many of the victims are of a very advanced age. Make a full disclosure of documents and materials in its possession with regard to comfort stations and other related activities of the Japanese Imperial Army during the Second World War. Make a public apology in writing to individual women who have come forward and can be substantiated as women victims of Japanese military sexual slavery. Raise awareness of these issues by amending educational curricula to reflect historical realities. Identify and punish as far as possible perpetrators involved in the recruitment and institutionalization of comfort stations during the Second World War. On January 31, 2007, U.S. Representative Michael Hondo of California, along with 6 co-sponsor representatives, introduced House Resolution 121, which called for Japanese action in light of the ongoing struggle for closure by former comfort women. The resolution was formally passed on July 30, 2007, and made 4 distinct demands. It is the sense of the House of Representatives that the government of Japan should formally acknowledge, apologize, and accept historical responsibility in a clear and unequivocal manner for its Imperial Armed Forces coercion of young women into sexual slavery, known to the world as comfort women, during its colonial and wartime occupation of Asia and the Pacific Islands from the 1930s through the duration of World War II. Number 2 would help to resolve recurring questions about the sincerity and status of prior statements if the Prime Minister of Japan were to make such an apology as a public statement in his official capacity. Should clearly and publicly refute any claims that the sexual enslavement and trafficking of the comfort women for the Japanese Imperial Army never occurred, and should educate current and future generation about this horrible crime while following the recommendation of the international community with respect to the comfort women. In December 2007, the European Parliament, the governing body of the European Union, drafted a resolution similar to House Resolution 121, entitled Justice for Comfort Women. The resolution demanded a formal acknowledgement of responsibility by the Japanese government, a removal of the legal obstacles preventing compensation, and an abridged education of the past. The resolution also stressed the urgency with which Japan should act on these issues, stating the right of individuals to claim reparations against the government should be expressly recognized in national law, and cases for reparation for the survivors of sexual slavery as a crime under international law should be prioritized, taking into account the age of the survivors. The Canadian and Dutch parliaments have each followed suit in drafting resolution against Japan. Canada's resolution demands the Japanese government to issue a formal apology, to admit that its imperial military coerced or forced hundreds of thousands of women into sexual slavery, and to restore references in Japanese textbooks to its war crimes. The Dutch Parliament's resolution calls for the Japanese government to uphold the 1993 Declaration of Remorse made by Chief Cabinet Secretary Yuhei Kono. The Foreign Affairs Committee of the United Kingdom's Parliament also produced a report in November 2008 entitled Global Security, Japan and Korea, which concluded that Japan should acknowledge the pain caused by the issue of comfort women in order to ensure cooperation between Japan and Korea. Statements of remorse made by representatives of the Japanese government. Various officials of the government of Japan have issued the following public statements concerning the comfort system. Statement by the Chief Cabinet Secretary Yuhei Kono in 1993. The government of Japan has been conducting a study on the issue of wartime comfort women since December 1991. I wish to announce the finding as a result of the study. As a result of the study, which indicates that comfort stations were operated in extensive areas for a long period, it is apparent that there existed a great number of comfort women. Comfort stations were operated in response to the request of the military authorities of the day, and then Japanese military was directly or indirectly involved in the establishment and management of the comfort stations and the transfer of comfort women. The recruitment of the comfort women was conducted mainly by private recruiters who acted in response to the request of the military. The government study has revealed that in many cases they were recruited against their own will, through coaxing, coercion, etc., and that at times administrative military personnel directly took part in the recruitment. They lived in misery at comfort stations under a coercive atmosphere. As to the origin of those comfort women who were transferred to the war areas, excluding those from Japan, those from the Korean Peninsula accounted for a large part. The Korean Peninsula was under Japanese rule in those days, and their recruitment transfer control were conducted generally against their will, through coaxing, coercion, etc. Undeniably, this was an act, with the involvement of the military authorities of the day, that severely injured the honor and dignity of many women. The government of Japan would like to take this opportunity once again to extend its sincere apologies and remorse to all those, irrespective of place of origin, who suffered immeasurable pain and incurable physical and psychological wounds as comfort women. It is incumbent upon us, the government of Japan, to continue to consider seriously, while listening to the views of learned cycles, how best we can express this sentiment. We shall face squarely the historical facts as described above instead of evading them, and take them to heart as lessons of history. We hereby reiterated our firm determination never to repeat the same mistake by forever engraving such issues in our memories through the study and teaching of history. As actions have been brought to court in Japan and interest have been shown in this issue outside Japan, the government of Japan shall continue to pay full attention to this matter, including private research related thereto. Prime Minister Tomichi Murayama's statement in 1994. On the issue of wartime comfort women, which seriously stain an honor and dignity of many women, I would like to take this opportunity once again to express my profound and sincere remorse and apologies. Letters from the Prime Minister of Japan to individual comfort women. The issue of comfort women, with the involvement of the Japanese military authorities at that time, was a grave affront to the honor and dignity of a large number of women. As Prime Minister of Japan, I thus extend anew my most sincere apologies and remorse to all the women who endured immeasurable and painful experiences and suffered incurable physical and psychological wounds as comfort women. I believe that our country, painfully aware of its moral responsibilities, with feelings of apology and remorse, should face up squarely to its past history and accurately convey to future generations. The Diet Japanese Parliament passed a resolution in 1995 and 2005. Solemnly reflecting upon the many instances of colonial rule and acts of aggression that occurred in modern world history, and recognizing that Japan carried out such acts in the past and inflicted suffering on the people of other countries, especially in Asia, the members of this House hereby express deep remorse. Resolution of the House of Representatives, adopted on June 9, 1995. Various public statement by Japanese Prime Minister Shinzo Abe. I have talked about this matter in the Diet sessions last year, and recently as well. And to the press, I have been consistent. I will stand by the Kono statement. This is our consistent position. Further, we have been apologizing sincerely to those who suffered immeasurable pain and incurable psychological wounds as comfort women. Former prime ministers, including Prime Ministers Koizumi and Hachimoto, have issued letters to the comfort women. I would like to be clear that I carry the same feeling. This has not changed even slightly. Excerpt from remarks from Prime Minister Abe at an interview by NHK, March 11, 2007. I am apologizing here and now. I am apologizing as the Prime Minister, and it is stated in the statement by the Chief Cabinet Secretary Kono. Excerpt from remarks by Prime Minister Abe at the Budget Committee at the House of Councillors, the Diet of Japan, March 26, 2007. I am deeply sympathetic of the former comfort women who suffered hardship, and I have expressed my apologies for the extremely agonizing circumstances into which they were placed. Excerpt from telephone conference by the Prime Minister Abe to President George W. Bush, April 3, 2007. I have to express sympathy from the bottom of my heart to those people who were taken as wartime comfort women. As a human being, I would like to express my sympathies, and also as Prime Minister of Japan, I need to apologize to them. My administration has been saying all along that we continue to stand by the Kono statement. We feel responsible for having forced these women to go through that hardship and pain as comfort women under the circumstances at that time. Excerpt from the interview article, A Conversation with Shinzo Abe, by the Washington Post, April 2007. Both personally, as a Prime Minister of Japan, my heart goes out in sympathy to all those who suffered extreme hardships as comfort women, and I express my apologies for the fact that they were forced to endure such extreme and harsh conditions. Human rights are violated in many parts of the world during the 20th century. Therefore, we must work to make the 21st century a wonderful century in which no human rights are violated. And the government of Japan and I wish make significant contributions to that end. From Prime Minister Abe's remark at the joint press availability after the summit meeting at Camp David between Prime Minister Abe and President Bush. The Asian Women's Fund, established by the Japanese government in 1995, the Asian Women Funds represented the government's concrete state attempt to address its moral responsibility by offering monetary compensation to victims of the comfort women system. The purpose of the AWF was to show atonement of the Japanese people through expressions of apology and remorse to the former wartime comfort women, to restore their honor and to demonstrate Japan's strong respect for women. The AWF pronounced 3 programs for former comfort women who applied for assistance: an atonement fund paying $2 million to each woman. Number 2, medical and welfare support programs paying 2.5 to 3 million yen for each woman, and a letter of apology from the Japanese Prime Minister to each woman. Funding for the program came from the Japanese government and private donation from the Japanese people. As of March 2006, the AWF provided 7 million yen, approximately 7 million, for these programs in South Korea, Taiwan, and the Philippines, 280 million yen in Indonesia, and 242 million yen in the Netherlands. On January 15, 1997, the AWF and the Philippine government signed a memorandum of understanding for medical and welfare support programs for former comfort women. Over the next 5 years, these were implemented by the Department of Social Welfare and Development. Our ruling, stripped down to its essential, the issue in this case is whether the Executive Department committed grave abuse of discretion in not espousing petitioners' claim for official apology and other forms of reparations against Japan. The petition lacks merit. From a domestic law perspective, the Executive Department has the exclusive prerogative to determine whether to espouse petitioners' claim against Japan. Baker v. Carr remains the starting point for analysis under the political question doctrine. There, the U.S. Supreme Court explained that prominent on the surface of any case held to involve a political question is found a textually demonstrable constitutional commitment of the issue to a coordinate political department or a lack of judicially discoverable and manageable standards for resolving it, or the impossibility of deciding without an initial policy determination of a kind clearly for non-judicial discretion, or the impossibility of a court's undertaking independent resolution without expressing lack of the respect to coordinate branches of government, or an unusual need for unquestioning adherence to a political decision already made, or the potentiality of embarrassment from multifarious pronouncement by various departments on question. In Tanada versus Cuenco, we held that political questions refer to those questions which under the Constitution are to be decided by the people in their sovereign capacity, or in regard to which full discretionary authority has been delegated to the legislative or executive branch of the government. It is concerned with issues dependent upon the wisdom, not legality of a particular measure. Certain type of cases often have been found to present political questions. One such category involves questions of foreign relations. It is well established that the conduct of the foreign relation of our governments is committed by the Constitution to the executive and legislative, the political departments of the government, and the propriety of what may be done in the exercise of the political power is not subject to judicial inquiry or decision. The U.S. Supreme Court has further cautioned that decisions relating to foreign policy are delicate, complex, and involve large elements of prophecy. They are and should be undertaken only by those directly responsible to the people, whose welfare they advance or imperil. They are decisions of a kind of which the judiciary has neither aptitude, facilities, nor responsibility. To be sure, not all cases implicating foreign relations present political questions, and courts certainly possess the authority to construe or invalidate treaties and executive agreements. However, the question whether the Philippine government should espouse claims of its national against a foreign government is a foreign relation matter, the authority for which is demonstrably committed by our Constitution, not to the courts but to the political branches. In this case, the executive department has already decided that it is to the best interest of the country to waive all claims of its nationals for reparation against Japan in the Treaty of Peace of 1951. The wisdom of such decision is not for the courts to question, neither could petitioners assail the said determination by the executive department by the instant petition for certiorari. In the seminal case of U.S. versus Curtis White, Export Court, the U.S. Supreme Court held that the President is the sole organ of the nation in its external relations and its sole representative with foreign relations. It is quite apparent that if, in the maintenance of our international relations, embarrassment, perhaps serious embarrassment, is to be avoided, respondents explained that the Allied powers concluded the Japanese treaty with Japan not necessarily for the complete atonement of the suffering caused by Japanese aggression during the war, not for the payment of adequate reparations, but for security purposes. The treaty sought to prevent the spread of communism in Japan, which occupied a strategic position in the Far East. Thus, the peace treaty compromised individual claims in the collective interests of the free world. We thus held that from a municipal law perspective that certiorari will not lie, as a general principle and particularly here, where such an extraordinary length of time has lapsed between the treaty's conclusion and our consideration, the executive must be given ample discretion to assess the foreign policy considerations of espousing a claim against Japan from the standpoint of both the interests of the petitioners and those of the Republic, and decide on that basis if apologies are sufficient and whether further steps are appropriate or necessary. The Philippines is not under any international obligation to espouse petitioners' claim. Regrettably, it is not within our power to order the executive department to take up the petitioner's cause. Ours is only the power to urge and exhort the executive department to take up petitioner's cause.